Elizabeth. I have the distinct pleasure to extend greetings from AJJF to all of you, and warm welcome to each one of you for having found time to participate in this discussing this crucial topic of threats, challenges, and most importantly, the mitigation measures, strategies that are pertinent to safeguarding the independence of the judiciary in our region. About judicial independence in our region really is talking in the situation of judicial independence in Africa. Yet this problem is not just African, although many people, many professionals, legal professionals might think of it as peculiarly African. No, nothing could be further from the truth. The street protests that we saw in Israel regarding Prime Minister Benjamin Netanyahu's judicial reforms, the street protests in Poland against the judicial reforms introduced by the immediate former government, and the tiff between Poland and the EU would show you that this is not just the desperation by successive US administrations to be the one that appoints the most judges, and particularly to the Supreme Court of the United States, tells you how important it is for sitting governments in the United States to be sure to guarantee their policies through a friendly judiciary. But also, this is reflected in the partisan rancor in the confirmation processes of judges. In the Senate, in the US Senate, and that many times is dependent on the politics of the day. The majority party many times is likely to have its way. But it also will come as a surprise that some of the debates that we are having locally here on judicial independence, such as the mode of selection and in other parts of Europe, because as you know, in the United States, while we are fighting very hard to diminish the role of the president and the role of the state in the appointment of judges, in the United States, judges are actually at the federal level, including those serving on the Supreme Court. Those judges are nominated by the president and confirmed by Senate. Okay, and then you also have the issue where at the state level, judges, the mode of selection of judges actually, while it's varied across the states, it also curiously the problem of judicial independence can problem. It is a world problem with an African accent. I think that's what we are dealing with. So at the regional level, of course, we have a number of difficulties, from undue political interference to insufficient resources and systemic inefficiencies. The threats to judicial independence are multifaceted and require comprehensive analysis and concerted action. Throughout this webinar, I hope we can delve into the specific threats facing the judiciary in West Africa, explore innovative approaches to mitigate these challenges, and identify actionable strategies to strengthen judicial independence. But very importantly, we will wish to draw upon the collective expertise and experiences of our esteemed panelists and all of you participants to generate meaningful insights and recommendations. I wish to extend my sincere appreciation to our program staff, led by Elizabeth, Justice, and others, Michael Mwesiga and Mamu, for having put this together. But in a special way, I would like to thank all our panelists for having accepted to come. Thank you very much, your lordships, my colleagues, land friends, and others. I wish that we have an open debate and be innovative on mitigation strategies. Thank you very much.
Okay, thank you very much, Secretary General, for the welcome remark. I would like to remind everyone that the webinar is being organized by African Judges and Juries Forum, Ghana Bar Association, Gambian Bar Association, West African Bar Association, and West African Law Students Association. We have a line of distinguished speakers who will take turns to address specific issues on the state of judicial independence in West Africa. We have on board Honorable Justice Joe Acha, Honorable Justice Zainab Jawara Alami, Ms. Victoria Bat, Professor Gabriel Arishi, and Ms. Libna Farash. They will all take turns to make remarks on different thematic issues. Dear participants, if you have any thoughts, comments, or questions, you can post it in the chat box. You will get a response at the plenary section. Yeah, thank you. Then I would like to acknowledge in the participants, Justice Charles Hongwe, our sponsors, Open Society Foundation, and others. Thank you for joining us. I would like to permit me to introduce the first speaker of the event. He served in the legal profession for over 40 years. He is the immediate Chief Judge of Edo State, Nigeria. During his career on the bench, he served as member of several election petition tribunals. He was a judge of the Independent Corrupt Practices and Other Related Offenses Commission. He's a member of the International Dispute Resolution Institute and a fellow of the Institute of Chartered Mediators and Conciliators. He has a certificate for dispute resolution Foundation from the Center of Peace, Democracy, and Development, University of Massachusetts, Boston. I have the honor to invite Honorable Justice Joe Acha to make a presentation on judges' perspectives on the state of judicial independence in West Africa. Over to you, sir.
Can you hear me?
Yes, we can.
You can hear me
Judge,
now.
we can now hear you, yes.
Yes.
Okay. I want to thank the organizers of this forum, of this conference, for coming up with such array of distinct jurists and judges to discuss this all-important topic on the independence of the judiciary in West Africa and share our various experiences from these various regions, the state, the countries with a view to finding a way to solving the problems that arise from lack of independence. There's no gainsaying the fact, I'm sure we will all agree, that the judiciary, particularly in the West African sub-region, are still tied to the apron string of the executive. When you speak of the judiciary as an arm of government, for me, it is just on paper. The judiciary are tied to the apron string of the executive. And unfortunately, most of our leaders in West Africa exercise what they believe as executive powers. The constitutions, the various constitutions of the various countries in West Africa have not helped matters. When we talk of independence, we want to start from the mode of appointment of judges and heads of courts. Then you talk of administrations, the daily administration of the judiciary, and then you talk of financial independence. I believe that the state government stands on a tripod, which is the executive, the legislature, and the judiciary. Unfortunately, the judiciary remains the weakest of the three legs that the government stands upon. And we find a situation where judges are appointed or nominated for appointment. And as the names are sent out, as today, the Constitution of Nigeria enjoins the State Judicial Service Commission to recommend candidates to the National Judicial Council, NJC, which in turn makes recommendation after screening and examination, as it were, to the state governors. So by and large, we find that most of the problems we talk about when we speak of the independence or lack of independence in the judiciary are largely at the state level. I will say in Nigeria, at the federal level, where you have the Federal Court of Appeal and the federal courts, they are to a very large extent independent, in that the heads of court and the Chief Justice of Nigeria is allowed to determine the operations of these courts. But at the state level, the judiciary are still under the supervision of state governors. Section 121, sub 3 of our Constitution states that monies, revenue for the state judiciary shall be transmitted and handed over to the heads of courts at the state level in Nigeria. But this provision is obeyed in the breach rather than obedience. This particular section 121, sub 3. So first and foremost, we have this adage which says that he who pays the piper dictates the tune. Where in a situation, even to make employment of a staff as little as a gardener or a driver, the head of court has to seek the permission of the governor of the state to employ such staff. And sometimes you may have your vision as a head of court, but you find that this vision is subsumed in the vision of whoever is the head of government, in this case, the governor. And I want to give a typical example. When I talk of the issue of appointment, there's a state in Nigeria where the NJC, in its wisdom, considered a list sent to it by the State Judicial Service Commission, and they examined the candidates and sent those they considered qualified to the state governor for appointment, because that is a requirement of the Constitution, that the final appointment is made by the governor. About 9 months down the line, the governor, as I said, you want to carry out a specific project, you have to go cap in hand, pleading with the governor to approve that project and release money where sometimes matters affecting the required independence. In my view, it is utopian, it is difficult. It is on paper, and we may all the same subscribe to that axiom that the judiciary that is independent is better for the country and for the state. But in practice, it is difficult for now to achieve this independence. So what is the way forward? In the last constitutional amendment, the president has signed into law the amended version of the Constitution, where the salaries, the pension administration of judicial officers have been taken to the NJC at the federal level. Because now, presently, the NJC pays the salaries of judicial officers of superior courts in Nigeria, but the allowances, which include vehicle, housing, clothing, are still within the ambit of the state government. So the state can still, at this moment, determine how to relate with the heads of courts and invariably with the judiciary, that the executive perceived to be uncooperative, the entire judiciary suffers. So we have to share our experiences and see how we can help ourselves. I'm out of service, so I can speak freely, and I can share my experience while in service with my colleagues and the body of jurists to see how we can help ourselves. Thank you very much.
Yeah, thank you very much, Judge. Currently, the High Court judge responsible for the court-connected AJRA system in the Gambia. She worked at the Ministry of Justice in different capacity and was also the head of legal department at the Gambian Revenue Authority for 10 years. She's a 2023 Westin Jams International Fellow and a member of the Honorable Society of Inner Temple, the United Kingdom. I welcome the Honorable Justice Zainab Jawara Alami to the judicial podium. Over to you, Your Ladyship.
Thank you very much, Madam Moderator. Good afternoon, fellow panelists that are here present. I am deeply honored to have been invited by the Africa Judges and Jurists Forum in collaboration with the West African Bar Association, the Ghana and the Gambia Bar Association to give remarks on the contemporary threats against judicial independence in West Africa. As was introduced, I am Honorable Justice Zainab Jawara Alami, a judge of the High Court of the Gambia, which is a tiny state in West Africa, known as the Smiling Coast of Africa, and known for its lovely beaches and lovely people as well. Let me begin my paper with a quote from the father of the principle of separation of powers, Montesquieu, who stated that there is no liberty when the judicial branch is not separated from the legislative and executive branches. Being united to the first, the rule over the life and liberty of citizens would be arbitrary, since the judge and legislature would be one and the same. Being united to the second would be tyrannical, for the judge would enjoy the same strength as an aggressor. This theory has led to the development of modern-day constitutionalism, entrenching the principle of judicial independence. The Gambia is no different from other sister countries in West Africa, particularly our English-speaking sister countries with common law traditions that have similar, if not identical, constitutions with entrenched principles stressing the importance of the judiciary not only being independent, but also appearing to be independent. In addition to our various constitutions, a number of international instruments have been adopted by countries throughout the world on the role of judges and judicial independence, more specifically in the Universal Human Rights System, including the UN Basic Principles on the Independence of Judiciary, 1985, and complementary to this, the Bangalore Principles on Judicial Conduct of 2006. Now, the basic principles states, amongst other things, the independence of the judiciary to be guaranteed by the state and proclaimed by the constitution or the legislation of the country. And all governmental and other institutions shall respect and abide by the independence of the judiciary. And it goes on. The Latimer House guidance on parliamentary supremacy and judicial independence in 2003 also applies only to the members of the Commonwealth, of which Gambia is a member of, and provides also on the independence of the judiciary to be an independent, impartial, honest, and competent judiciary. It is integral to upholding the rule of law, engendering public confidence, and dispensing justice. The function of the judiciary is to interpret and apply national constitution and legislation consistent with international human rights, conventions, and international law to the extent permitted by the domestic law of each Commonwealth country. Section 123 of the Constitution of the Gambia, 1997, also makes such a similar pronouncement in that, that the exercise of the judicial functions, the courts, the judges, and other holders of judicial office shall be independent and shall be subject only to the Constitution and the law, save as provided in this chapter, shall not be subject to control or direction of any other person or authority. This provision in my constitution makes it crystal clear that the judiciary is independent. And it goes as far as to state that the government and all departments and agencies of the government shall accord such assistance to the courts as the courts may reasonably require to protect their independence, dignity, and effectiveness. Despite the adoption of all these international and regional instruments and domestic laws aimed at ensuring the importance of judicial independence, and despite also the pronouncements of the drafters of our various constitutions that our jurisdictions are completely independent from other branches of government, our judiciaries are faced with challenges that impede our independence. And in turn, I will ask the question, how independent really are our judiciaries in West Africa? The state of judicial independence in West Africa faces various threats and challenges, some of which are common across the region, while others may be specific to certain countries. I will answer the question on the basis of my country's experience, simply because it is worth acknowledging the unique experience my country went through during the 22 years of dictatorship and its impact on the judiciary of the Gambia. A number of factors that I will highlight will, I am sure, resonate with some of us here present. One of the primary threats to judicial independence is political interference, and this can manifest in the form of executive influence over judicial appointments, decisions, or the overall functioning of the judiciary. Section 138.2 of the Constitution of the Gambia makes the President the appointing authority for the Chief Justice in consultation with the Judicial Service Commission and judges on the recommendation of the Judicial Service Commission. While Section 1414-9 of the 1997 Constitution provides the criteria and a lengthy procedure for the removal of the judges, Section 142C of the Constitution also gives the power to the President in consultation with the Judicial Service Commission to terminate the appointment of a judge. The Gambia has had first-hand experience in political interference for 22 years under the former regime, where judicial officers in the superior courts and the magistracy were dismissed without following the right procedure. Section 1412C was widely used by the former regime as a tool to control judges and did not at any time consult the Judicial Service Commission in their removal. During this time, to name a few incidents, 2 Chief Justices were dismissed and 1 was given 48 hours to leave the jurisdiction. 3 Supreme Court judges were dismissed because they gave contrary decision in cases of political interest. Court of Appeal and High Court judges and even the magistracy were not spared. Thus, one can see how easy it is for constitutional provisions to be used perversely to control the judiciary. Another threat to the independence of the judiciary is resource constraints, and in particular, financial resources. Many West African countries struggle with limited resources allocated to the judiciary, including inadequate funding, staffing shortages, and insufficient infrastructure. These constraints can affect the judiciary's ability to operate effectively and independently. In from the Consolidated Revenue Fund or funds appropriated by an act of the National Assembly shall be paid to the judiciary as required by the Chief Justice. This section further allows the Chief Justice to submit the annual budget of the judiciary to the President, who shall place the estimate before the National Assembly with comments only and no amendments. This is not the practice in reality. The practice of the judiciary before 2018 was to hold budget bilateral negotiations with the Ministry of Finance, who would determine the allocation of resources to the judiciary, a practice clearly not supported by law. In some jurisdictions, the Chief Justices receive subventions for the judiciary on a 6-monthly basis, rather than every month as pertains in the Gambia and other judiciaries. Thus, the objective of a self-accounting judiciary is far from realized. The lack of adequate financial resources also leads to the lack of training and capacity building within the judiciary. It is a fact that the lack of adequate training and professional development opportunities can impede the abilities of judicial officers to uphold the rule of law and protect judicial independence. How do you fiercely guard your independence when you're not equipped to do so? Still on the lack of adequate financial resources, this can also lead to security concerns. Lack of financial resources seriously compromise the security of judges and other judicial personnel. A case in time is a judicial officer having to use public transport to get to work. Imagine what would happen if the officer was to come in contact with someone he or she convicted. This may seem impossible in big jurisdictions, but not in a small country like my own. Judicial officers also face threats to their safety and security, particularly when handling sensitive cases or challenging powerful interests and without adequate security protection. How is a judicial officer to administer justice without fear? Corruption is also another factor that impedes the independence of the judiciary. Corruption in the form of bribery, favoritism, and nepotism are also factors that can undermine the independence of the judiciary. This also erodes public trust and seriously compromises the integrity of judges and court proceedings. The independence of any judiciary would require the freedom from any influence or control by the executive or legislative branches. And to secure these aims, I've come up with a few mitigation strategies And one of them is legal reforms, in particular, constitutional amendments. This is necessary and is required for the appointment and removal of judges. Judicial appointments should be made on the basis of clearly identified criteria and by a publicly declared process, as happens in South Africa and in Kenya. The process should ensure equality of opportunity for all who are eligible for judicial office appointment on merit, and that the appropriate consideration is given to the need for progressive attainment of gender equality. Most importantly, it is necessary to enact a separate law that will address duration of the terms of office and security of tenure for judges. This will guarantee the judicial independence and insulate the judiciary from public interference. These are also some of the considerations of the Latimer House rules. Strengthening institutional frameworks, enhancing the institutional capacity of judicial bodies such as the Judicial Service Commission or councils, established by the Constitution or by statute as an independent institution, or to include a mixture of judicial members and non-judicial members that are established with the functions to appoint, promote, and discipline judges, and also to ensure some level of accountability. This would go far to ensure independence in the judiciary. As I've said before, financial resources need to be adequate for the judiciary to function effectively without any undue constraints which would hamper the independence sought. The financial autonomy of the judiciary, as envisaged in the Constitution, must be realized. Anti-corruption measures should also be put in place, implementing robust anti-corruption mechanism within the judiciary, such as transparent appointment processes, ethical codes of conduct, and disciplinary measures will go a long way to ensure that independence is realized. Also, training and capacity building, investing in ongoing training programs for judges and court staff would enhance their skill, knowledge, and professionalism. And this is a sine qua non to an independent judiciary. Providing adequate security measures to protect judges and judicial personnel from intimidation, threats, and violence is also required. Public awareness and education. The more educated the public is on the role of an impartial judiciary in promoting democracy and safeguarding human rights would also go a long way to ensuring judicial independence. Collaborating with regional and international organizations to share best practices, exchange expertise, and to provide technical assistance in strengthening judicial independence is also a required goal. While these strategies can help mitigate threats to judicial independence in West Africa, addressing underlying political, socioeconomic, and cultural factors may require sustained efforts and a multi-stakeholder approach involving governments, civil society, legal professionals, and the international community is needed. I thank you very much for your attention.
And thank you very much, the leadership, for that brilliant and super presentation. I'll quickly like to flag out these points made by Justice Archer and Justice Alami. They stated that the judiciary are still tied to the apron strings of the executive. They talked about political interference, appointments of judges, and they talked about inadequate financial funding for judges. Then they talk about constitutional amendments that should have, they talked about constitutional amendment. Then they talked about how the way forward. They talked, Justice Alami talked about talking about providing adequate security measures for judges and lawyers, and providing financial stability for judges and lawyers also. Thank you very much, your leadership and your lordship. Then I'll quickly hand over to the president of the West African Law Students Association, Mr. Nazir Sanusi. You will handle the next session. Over to you, Nazir.
Good evening. Good evening.
We can hear you, Nazir. Go on.
I'm deeply honored to address the next segment of this important session. Let me begin by reading the CV of our short bio of our next speaker, Ms. Victoria Bar. Ms. Victoria Bar is a seasoned legal practitioner in Ghana. She is well respected within the Ghanaian legal community for her ethical driven practices, delivering the best outcome both in litigation and through alternative dispute resolution mechanisms. She is the managing partner and head of litigation and dispute resolution at Sam Okujeto and Associates, a leading law firm in Ghana. She is the head of faculty for advocacy and legal ethics, Ghana School of Law, and chair of the Ethics and Compliance Committee of the Board of Prudential Bank, Ghana. She has served on several boards and honors speaking engagement on a wide range of topics. The podium is for you. Thank you so much.
Go on, Ms. Victoria.
Oh, thank you. I'm sorry, I didn't hear the last bit. So it's my singular honor and privilege to have the opportunity to serve as one of the panelists on this august platform. And it is interesting that as a justice from the Gambia was presenting her paper, as well as the retired judge from Nigeria, I could see the Ghanaian experience mirrored. And so I will try not to be repetitive while at the same time highlighting the common challenges that our judiciary face as far as their independence is concerned. The focus of my presentation is on the lawyer's perspective on the threats to judicial independence in West Africa. And I believe most of these threats have already been highlighted by the preceding speakers. The two main ones that I'll be focusing on have to do with political influence and lack of financial autonomy. But before I delve into those, let me just emphasize that the threats that were identified in the earlier presentations are also threats that the judiciary in Ghana face. And these have to do with corruption, instances where judges in their individual capacities may be bribed to sway their decisions, thereby undermining the integrity of the judiciary. And I know that some of you may be familiar with the 2015 judicial scandal that unearthed bribery issues and which led to some overhaul in the workings of the judiciary. You also have threats and intimidation where judges and their families may face threats to their personal safety in cases that involve high profile or politically sensitive issues. Then you have lack of resources, which has been touched on, and as I said, political interference. So Ghana in its constitution has very beautiful provisions which seek to safeguard the independence of the judiciary. And two that I will highlight, first, Article 125 of the 1992 Constitution, which provides in the Article 125(1) that justice emanates from the people and shall be administered in a republic by the judiciary, which shall be independent and subject only to the Constitution. Then you have Article 127, which also provides as follows. 127(1), in the exercise of the judicial power of Ghana, the judiciary in both its judicial and administrative functions, including financial administration, is subject only to this Constitution and shall to the president or parliament, nor any other person whatsoever shall interfere with judges or judicial officers or other persons exercising judicial power in the exercise of their judicial functions, and all organs and agencies of the state shall accord to the courts such assistance as the courts may reasonably require to protect the independence, dignity, and effectiveness of the courts, subject to this constitution. And then it also guarantees the immunity of the judge by providing that a justice of the Superior Court or any other person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. So textually, Article 127(2) of the Constitution puts the institutional independence of the judiciary beyond dispute. However, in looking at what happens in practice, it is evident that the judiciary is not as financially independent as is intended by the Constitution. So financial independence encompasses the judiciary's ability to operate banking facilities without external influence or interference, save for audit purposes by the Auditor General. It also means they should be able to handle funds and their expenditure. And this should not be something that is manipulated by the executive. However, even though the judiciary prepares its own budget estimates as provided in Article 179 of the Constitution, and the executive is not permitted to revise the budget, but can only comment on it or make recommendations. Nonetheless, the administrative expenses of the judiciary are subject to the national budgetary process and therefore are proposed by the executive through the Minister of Finance to be approved by Parliament. And as the first speaker said, he who pays the piper calls the tune. And this loophole in terms of how the budget is presented for approval, it gives an effective trump card to the executive against the judiciary and has the potential to undermine their independence. The executive branch, therefore, emerges as the primary contender against which the demand for judicial independence must be directed. Funds allocated by Parliament or drawn from the consolidated fund for the judiciary, according to the Constitution, must be disbursed to the judiciary in quarterly segments. However, the executive frequently neglects to follow this requirement, and there is a lack of a viable mechanism to effectively address the non-compliance. And the usual recourse to Article 2 and 130 of our constitutional mandate is not adequate in dealing with that problem. Typically, when the executive fails to promptly release approved funds for the judiciary, the only recourse available to the judiciary is to engage in discussions with the executive to expedite the release. This approach, as you may agree with me, is undesirable because it creates the perception that the executive can influence the autonomous financial operations of the judiciary by withholding funds. And one may wonder what financial autonomy means when the Chief Justice is periodically compelled to engage or chase the executive to ensure the release of funds that have already been approved for release by Parliament for the judiciary's operations. Again, the judiciary is often treated as though it's a segment under the Ministry of Finance by virtue of some financial regulations whose application to the judiciary compromises its constitutionally mandated independence. For example, in a 2022 report by the Auditor General, it was revealed that a minimum of 16 judges of the Superior Court had acquired duty post vehicles in contravention of a regulation within the public financial management regulations. That regulation 158 stipulates that the principal spending officer of a covered entity must obtain prior written approval from the minister for any transfer, exchange, sale, donation, contribution in kind, trust, or other disposal of vehicles belonging to the covered entity. And the term covered entity, as per the Public Financial Management Act, encompasses the executive, legislature, and judiciary. Now, this is in clear violation of Article 127 of the Constitution, which I earlier referred to, which states that in the exercise of judicial power in Ghana, the judiciary in both its judicial and administrative capacities, including financial administration, is answerable only to the Constitution and should not be subject to the control or direction of any individual or authority. There have been moves, for instance, by civil society, and in 2023, the Institute for Liberty and Policy Innovation, noted that this trend of withholding funds, if not checked, will compromise the independence of our courts and parliament by jeopardizing the democracy that we're seeking to build. And they have advocated for a complete financial independence of both the legislature and the judiciary, which will be free from any financial restraints or constraints from the finance ministry. That remains to be seen and done. Interestingly, Nigeria seems to be a bit ahead of Ghana in that vein. They have a section 81(3) in their 1999 federal constitution, which categorically provides for how the judiciary at all levels should be funded. And the provisions in Article 81 have been affirmed by the High Court of Nigeria in several unreported cases, including Olisa, Agbakoba, and the AG Federation. And essentially, the petitioner in that case, before the High Court, the government of the case was that the judiciary had continued in palpable neglect, notwithstanding the independent funding granted it under the Constitution of the Federal Republic of Nigeria, 1999. And that the judiciary depends on the executive for its budget and release of funds, which undermines its independence. And the court recognized the importance of maintaining the financial independence of the judiciary, emphasizing that the alteration of the judiciary's budget estimates over time had been detrimental to the effective and efficient administration of justice. We need to see a similar intervention in Ghana. Now I move on to appointments of Superior Court justices where political or the executive influence manifests significantly. Appointment of Superior Court judges is provided for under Article 128 of the 1992 Constitution, which provides that the Supreme Court shall consist that can be appointed to the Supreme Court is not provided by the Constitution, as in there's no cap. So this creates the opportunity or enables a president with the approval of Parliament to keep adding to the number. And there are concerns that where a president with a parliamentary majority perceives the Supreme Court to be unfriendly, he or she may appoint more judges to neutralize the perceived opposition. And this can seriously undermine the judiciary's independence and even public perception or confidence in the administration of justice. Incidentally, the opposition leader in Ghana has recently made a statement publicly based on his observation that there appears to be a packing of the superior courts with persons who are sympathetic to the ruling government. He has made a statement that his people should be ready, and that should he come to power following the next election, he is also going to appoint his people, in quotes, to the bench. Now, that clearly shows that the motivation is no longer about necessarily identifying competent persons of integrity to appoint to the bench, but rather about packing the courts with persons who are perceived to be sympathetic or who owe allegiance to the ruling party. There are also concerns about empaneling judges for the court's work. The normal bench of the Supreme Court is duly constituted by 5 justices and 7 for its review jurisdiction under Article 133 of the Ghanaian Constitution. The empaneling of the judges is at the discretion of the Chief Justice, and this could encourage forum shopping. And one has to bear in mind that the Chief Justice is also an appointee of the government. Article 144(2) of the 1992 Constitution of Ghana on the appointment of other justices of the Supreme Court provides that the other Supreme Court justices shall be appointed by the President, acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. The Council of State, the Judicial Council, and Parliament play vital roles in the appointment process of these Supreme Court judges, and their role is expected to contribute to the prospect of enhancing the credibility and the independence of the judges who are appointed. However, in practice, that is not necessarily so, because when the President's party commands parliamentary majority, the approval of the appointments become a mere formality, since a simple majority approval is required. Again, the advice of the Council of State and even the Judicial Council is not legally binding on the President. In 2015, the Ghana Bar Association had cause to file a case before the Supreme Court, Ghana Bar Association and others versus the Attorney General and Judicial Council, for the court to interpret the import of the President acting in consultation with the Council of State and on the advice of the Judicial Council in appointments of Supreme Court judges. And the Supreme Court held that the President was not bound by the advice of the Judicial Council, neither by its consultations with the Council of State. It is noteworthy that even the members of the Council of State are appointed by the President and therefore could be prone to accept his decisions on a list of nominees that he submits to the Judicial Council. The court, however, noted that the President, although not bound by the advice of the Judicial Council, cannot make any appointments outside the shortlisted nominees submitted by the Judicial Council. However, there's this emerging trend now where we see lists of nominees emanating from the President to the Judicial Council. And it is now looking as though the Judicial Council is more of a rubber stamping entity. And that is a major concern when it comes to the independence of the persons who end up being appointed to the superior courts. The Judicial Council itself, the composition is such that the President has 4 persons that he nominates, and then there's also the Attorney General who doubles as a lawyer for the government and the President. And then also the Chief Justice, also an appointee of the President, who is on the Judicial Council. So apart from the fact that their advice is not binding on the President, their very composition also is materially, there's a material representation by appointees of the government. So it has become critical for Ghana to have a look at Article 128 of its constitution to see if there can be some reforms that will limit the opportunity for abuse by a president, and a president who has a majority in parliament. Based on the time allocation, I will limit myself to these two that I have delved into and associate myself with the recommendations and the mitigation measures proposed by the speaker from the Gambia. Safe to add that for our high courts, we have the e-justice system where technological interventions are used in the allocation of cases. And one of the recommendations or measures that we would hope to see implemented will be exploiting that e-justice system for allocation of cases in the Court of Appeal and the Supreme Court as well, so that allocation of cases is not just left to the discretion of the Chief Justice. Again, promotion of our judges must be on merit. There must be more transparency in that process. Also, training, as was earlier alluded to, and public awareness. There's the importance of a well-informed media in monitoring and advocating for judicial independence. I'll pause here.
Hello, Nazir. Hello.
Hello?
Nazir. I would like to call on the next speaker. Oh, he'll be talking on the same thematic issue. Professor Gabriel Arishe from the University of Benin, Nigeria. Thank you.
All right, thank you, Elizabeth. Let me begin by thanking the African Judges and Jurists Forum in partnership with the Ghana Bar Association, the Gambian Bar, and the West African Bar Association for inviting me to speak on this all-important topic. I'd like to thank all the judges who have spoken and for the useful insights that they have made on this. I'll go straight to what I've been asked to speak on, a lawyer's perspective on emerging threats to judicial independence in West Africa. Permit me to begin by saying something about judicial independence. At the very basic, judicial independence means that a court or a judge delivers decisions and resolves disputes free from external influence coming from outside sources, especially the other branches and the powerful in the society. There are three types of independence: personal, substantive, and internal. There is personal independence for the judge when the terms and conditions of judicial service are adequately separated from executive control, such that judges do not feel that they owe allegiance to any political paymaster. It doesn't matter if the political branches approve the budget, but it shouldn't be done in such a way that they have a wide discretion as to when to release funds. It shouldn't be. The process should be institutionalized such that The budgetary process is not subject to the personal control of any official in the political branches. That goes for personal independence. Then we'll go to substantive independence. This exists where in the discharge of his or her judicial function, the judge is subject only to the legal system and his or her conscience, not to anybody. Even if the decision turns out to be against the government, there isn't going to be any punishment at all. The government accepts it. Then we will say there is substantive independence. Then what about internal independence? If in the decision-making process, he or she is free from control vis-a-vis his or her judicial colleagues, then there is internal independence. I'm going to speak on this because you find a situation where judges are subjected to pressures from senior colleagues. Sometimes we've heard instances, I've had to talk with friends who said, oh, I was called by this senior colleague over this matter. So for there to be independent for judges, the judges must be the authors of their own opinions without any pressures from anywhere. So decisions should be binding on the state. Because if you say that there is judicial independence, a judge makes a decision, but it is not binding at the end of the day, then there is a problem. Over time, judges will become discouraged. Over time, society will no longer take that institution to be authoritative. I'll give you some examples of what happened in Nigeria. Most time, people cite the case of Rotimi Amechi and INEC, where the Electoral Act 2002 was amended, and then there was this section 34 that said that you cannot substitute a candidate as a political party without cogent and verifiable reasons. After primaries had been done by the ruling People's Democratic Party at the time, Rotimi Amechi, who is from Rivers State in South Nigeria, emerged the flag bearer. But the party hierarchy in Abuja decided to remove his name, and then another person's name was submitted to INEC. Rotimi Amechi went to court to challenge that decision. The matter started from the Federal High Court. Before the matter was decided eventually by the Supreme Court, the general elections are taking place. And then the person that the PDP submitted, Mr. Celestine Omeha, had been sworn in as the governor of Rivers State, and indeed has spent about 3 months when the Supreme Court gave its decision. And the Supreme Court said the PDP could not give a cogent and verifiable reason. And because of that, the Apex Court ordered that Rotimi Amechi should be sworn in instead of Mr. Celestine Omeha. But something similar happened in Imo State. The same time, the man who won the PDP primaries conducted the same period like that of Rivers. His name was Ifeanyi Ararume, who was indeed a 7th senator. He won, but his name was removed. And then another person's name was submitted by the PDP, Mr. Charles Ugu. And then he rushed to court. Unlike Mr. Rotimi Amechi, Mr. Ararume's case was faster. The Federal High Court in his own state decided the matter quite early. It went to the Court of Appeal. The Court of Appeal in his own region handled the matter expeditiously, and it got to the Supreme Court, and the Supreme Court gave a decision before the general election. Same facts, same scenario. But the PDP at the time said, fine. The Supreme Court says we cannot do what we want to do. So they said they were no longer interested in the election. So there was a judgment for Senator Ifeanyi Ararume, but the PDP said it was not going to feed any candidates for that election for the governorship position of that state. In essence, that rendered useless the decision of the court. Now, when that happens, over time, it makes the effort of the judges to be of nothing. And it has happened over again. In Federal Republic and Dasuki, the court ruled you have to release Dasuki, but the federal government refused, federal government of Nigeria. The same with the Federal Republic of Nigeria and El Zazaki. The court ruled that the leader of the Muslim sect in Nigeria should be released, but he was not released. They cited different reasons, but the man has been released today. And Nigeria is together anyway. The heavens did not fall. So if there should be, if we say there is judicial independence, one of the indices is that the decisions of judges are obeyed. It's very important. Now, what are the contemporary threats? Well, that's the main thing I'm to speak on. Number one, personal rule. You see, when the political leaders, say the president or the ruling party, the dominant party, wants to ensure political dominance such that you have a one-party system, in which case the opposition parties are embroiled in internal disputes. Then, what do you expect? They want to infiltrate the judiciary, use the judiciary to cause crisis in opposition parties, and then use the judiciary to rig election, as somebody said. So go to the polls, rig your way through, go to court, and ensure that the judiciary approves of your election. Personal rule is a problem. Now, when you find this authoritarian display by politicians, they target institutions that can check them. And one institution that can check them is the judiciary. Yeah, of course, the legislature can check them, but the legislature is also made up of politicians who may want to benefit too. So it's easy to bargain with legislators. Oh, if you support us, you defect to our ruling party, to the ruling party. You don't worry. We'll ensure that you get re-elected. That settles them. But what about the judiciary? You want to put pressure, and let's borrow the language of Professor Chidi Odinkalo, who will say that they capture the judiciary. Because to ensure that personal rule is sustained, then institutions that can act as a check are most times subdued. So personal rule is a big challenge. Number two, electoral crisis. Particularly when it comes to rigging of elections deliberate. It's a policy of ruling parties across Africa most times, except you may just mention one or two countries going by the scoring of countries, just exempt Botswana and UN. But it's an official policy that when you are in government, ensure that you corrupt the electoral process. And of course, to corrupt the electoral process successfully, institutions of states that can act as a check, principal among them being the judiciary, must be subjugated. It's a policy, an official policy. And now when you find the politicians who control the funds, who control the agencies of violence like the police, the army, now targeting an institution that doesn't control any of this, it becomes a problem. And then it appears that the judges become an endangered species. These are some of the challenges that we have. I'll just run through others because others are there because of the first two that I've mentioned. Personal rule is basically authoritarianism to ensure a dominant party system. And then the next that follow to ensure that this authoritarianism is sustained and that the dominant party system is sustained is the corruption of the electoral process. Then other problems that I'll mention are utilized to achieve these two other aims, personal rule and the corruption of the electoral system. And what are they? The recruitment process. That's another challenge. A recruitment process that, in the case of Nigeria, is almost hereditary now, or an attempted primogeniture, where father appoints son and son appoints, no, it's now generational. And then there's this other problem in the recruitment process, which Honorable Justice Archer mentioned, a streamlined recruitment. You deliberately would not want to appoint judges. It's a policy because you are not sure of their allegiance. It happened at the Supreme Court. Until recently, we did not have the full bench for over a decade. And even when they were appointed and ratified by the Senate, swearing them in was a problem because there was no accommodation for them. It means we were not even prepared to have a full bench. So you have this streamlined recruitment. Let us not have enough. So if we have 50 judges, that is just enough. Whereas you can have 100. But why do we need 100? Who are these persons coming? So it's a problem. It's a political strategy. And then what follows is financial autonomy. The lack of it is deliberate. There was a question that was posted which I answered. This financial autonomy thing, how do we go about it? The problem is sociological and less juristic. Nigeria has a lot of law. The constitution has been amended to say, look, as these funds come, give them to the heads of courts. Justice Joe Archer has told us he was the head of the court. That will not happen. Why? Because a governor feels he shouldn't do so. It's a problem. So what else do we do? What else should the law say? I said, maybe the law now says, well, if a governor or the head of the executive fails to do that, it's a criminal offense. Maybe. I don't know if we can go that far. And then another problem, which is number 5 here, the number of cases, the docket of the court. Judges handle so many cases. And, the commercial cases are there lying. We hear more of the political cases because they are given prominence. A political case arises today. You want to decide it quickly. And then you think the judges have less work or the judges are productive. But you institute a land matter, institute a commercial dispute, and you see how long it will take for that case to be decided. In Nigeria, my country, sometimes 5 years. If your commercial dispute is resolved by the courts, the court of first instance, within 2 years, you are lucky. It's a problem. So you have so many cases. So why don't we have more judges commensurate to the number of cases, at least? And then number 6 challenge here, facilities. It's surprising that we don't even have new facilities coming up. It's a problem. New facilities are not coming up at all. The state of digitalization of our court is very slow compared with the pace at which the world is going, and then artificial intelligence is taking over the place. We are very slow, and we are behind the curve. Quite unfortunate. Number seven, so that I wrap up, we have the quality of advocacy. It's a problem. The quality of advocacy by lawyers is going down. The level of research now seems to be going down. And I'm sure our judges who are in this forum right now, we attest to this. The quality of advocacy has diminished. Maybe training, we'll go to number 8. The training at our law schools in Africa will need to improve. And then I will mention something. The quality of research by my colleagues and the quality of publication. There's something I always say. Pick, I don't know if other jurisdictions, maybe members from other countries will be able to speak, but pick law journals from Nigeria. Look at the authors. You hardly find a professor. Once people become professors, they stop publishing. They stop researching. because there's no incentive. The incentive to publish is promotion. But when you hit the chair, then why publish anymore? That is not good enough. We must help the bar and help the bench by the quality of our research and publication. And then lastly, number 9, challenge, bullying. Yes. Senior colleagues call high court judges to say, look, that matter, you must do this. I've heard it from friends who are judges, that oh, you hear a senior calling you to say, that matter, you have to decide it this way because this politician is interested in that case. And I've heard a lawyer told me that he was called by the judge handling a matter that, look, this case you brought before me, settle it out of court. I'm telling you, you must settle it out of a private discussion, not in the open court. You must settle it out of court because of the interest involved. Now, what are the mitigation strategies? Number 1, democratic consolidation. We must improve on our democracy. Answer the question. The question on this forum, the question was, what do we do? Is there a model in Africa on judicial independence? And I said, well, Botswana seems to be the best.
Professor Rishi, sorry, you have exceeded your time limit.
Oh, okay, I'll just use a minute to wrap up now.
Okay,
so
thank you.
Democratic consolidation is number 1. Then number 2, civil society involvement, and that has been mentioned to ensure advocacy. And then there's this one I would prescribe for judges, in spite of the difficulties, self-assertion. Yes, it's a sacrifice. Judges who are still serving, who have not had the misfortune of being dismissed, should assert themselves and give them and be bold. And then other recommendations such as recruitment and so on, I align myself with what other speakers have said so far. Thank you so much for listening to me. Thank you. Yes, I'm done.
Yeah, thank you very much, Professor Rishi.
Thank you.
Yeah, I'll now hand over to Mr. Chidi Udekwe of the West African Bar Association. He will take the next section. Over to you, Chidi.
Thank you very much, Elizabeth. I welcome all panelists and all participants to this webinar. Good afternoon, all. So I've been called to introduce the 3rd section of this webinar. And we have in our midst Ms. Faraj, who is going to be discussing our next thematic paper having to do with the solutions. Ms. Faraj, by way of introduction, is a lawyer with growing reputation in the Gambia and overseas. She has been representing international investors for over 15 years. Ms. Faraj is a member of the Honorable Society of Lincoln's Inn and founding member of the Female Lawyers Association in Gambia, of which she previously served as Secretary and Vice President. She has also served as the Secretary General and President of the Gambia Bar Association. She has taught at the law school and conducted training of magistrates in the Gambia. Ms. Faraj has also served as the chairperson of the National Anti-Human Trafficking in Persons Agency, NATIP. She is currently serving as the board member in Gambia Technical Training Institute and the University of the Gambia. Gentlemen, I present to you Ms. Faraj to take us on the next topic. Thank you very much. Ms. Faraj, the floor is open for you, please.
Thank you very much, Mr. Chidi. Firstly, I'm truly delighted and humbled to take part in this webinar and to be amongst judges and professors and colleagues alike across West Africa. I'm especially pleased to be amongst members of the legal field in Ghana and Nigeria, since those two jurisdictions we've benefited immensely from those two jurisdictions. I have been asked to speak on measures to address challenges against judicial independence. This, regrettably, is not a new topic in the Gambia. And after 20 years since I joined the profession, I haven't seen that it's been addressed, and the issues that have been negatively impacting the independence of the judiciary still exist. Back in 2006, in August, the International Bar Association and Human Rights Institute issued a report as a result of a fact-finding mission to the Gambia, which took place in June 2006. The mission was prompted by concerns regarding the status of rule of law, the independence of the judiciary, and the ability of the legal profession to exercise its professional duties freely. They observed as follows, and I summarize only the points pertinent to our discussion. The judicial system in the Gambia suffers from neglect, underinvestment, and a severe lack of resources and infrastructure resulting from a general deprioritization of its importance. There are a number of infrastructure needs which affect the proper administration of justice. The lack of law reporting is a particular concern as it restricts the judiciary in its fundamental duty to give reasoned judgments. The lack of stenographers and court reporters further impedes the judiciary in carrying out its duties effectively and contributes to the backlog of cases. And then there's the absence of IT support, inadequate research facilities, and so on and so forth. Another observation the IBA had was that the constitutional appointment procedure for judges, given the dominance of the president and the executive over the appointments to the Judicial Service Commission, the apparent lack of transparency with respect to the JSC processes, the absence of clearly elaborated selection process, and the criteria for judicial appointment exposes judicial appointments to political influence. There are serious concerns that the appointment of contract judges operates outside the constitutional appointment procedure, and that the precise role of the JSC in this regard is unclear and limited. Now, I started off with 2006 because I joined the profession a few years before, about 3 years before. And here we are in 2024, nearly 20 years from the report, from the time that the report was issued, and things have not progressed much. Historically, we've learned of the doctrine of separation of powers, which my lady, Justice Juwara Alami, touched on, so I'm not going to go into that. And in the Gambia, democracy exists today. The doctrine of separation of power exists, in theory. Yes, our Constitution provides for the separation of powers of the executive, the legislative, and the judiciary under chapters 6, 7, and 8, respectively. And yes, the judiciary, being part of the Gambia's government, is directly responsible for the legal system, including all judges in the country's courts. Though the judiciary is broadly made up of lawyers, judges, and other officers charged with the responsibility of advocating and interpreting the law, as well as aiding the legal process of the law, for our context, I have limited it to judges at all levels of the courts, meaning from the Supreme Court down to the district tribunals. Under our Constitution, the judicial powers of the judiciary is stipulated that it's vested in all courts and exercised by them according to their respective jurisdictions conferred to them by law. This is in Chapter 8 of the Constitution. In exercising their judicial functions, the courts, judges, and other holders of judicial office shall be independent and shall be subject only to the Constitution and the law. This shows the great importance of the powers of the judiciary, such that nothing can rid the court of law of its powers and sanctions. Additionally, our beautiful Constitution provides that the government and all departments and agencies of the government shall accord such assistance to the courts as the courts may reasonably require to protect their independence, dignity, and effectiveness. Now, looking at what is judicial independence. It is the principle which stipulates, and we all know, and ensures that judges are not subjected to pressure and influence when adjudicating matters and are free to make impartial decisions based solely on fact and law. The very important position occupied by the judiciary in the Gambia, as buttressed by our constitution, provides that the National Assembly, in its legislative powers, shall not pass a bill to alter the decision or judgment of a court in any proceedings to the prejudice of any party to those proceedings, or deprive any person retroactively of vested or acquired rights. That's in section 100. This means that no law can be made purportedly to oust the jurisdiction of a court of law. What then are the attributes of an independent judiciary? An independent judiciary, we know, is determined by the mode of appointment of judges, the mode of removal of judges, remuneration of judges, security of tenure, freedom from political interference, amongst others. In the Gambia, if you look at our website, the Gambian judiciary's website basically states similar points. The mission statement of our judiciary is to advance the courts of justice and the rule of law by ensuring a free, fair, and speedy dispensation of justice by an independent judiciary, an efficient justice delivery system with highly trusted and committed staff that will command and support the confidence of the people. The role and responsibilities of the judiciary of the Gambia, like in many other countries, plays a crucial role in upholding the rule of law, ensuring justice and safeguarding the rights and freedoms of its citizens. It goes on to state about what the typical roles and responsibilities of the judiciary is. And in terms of interpreting laws, I'm not going to go into detail because of time constraints. Adjudicating disputes, ensuring fair trials, protecting rights and freedoms, reviewing laws and executive actions, appointing and disciplining judges, providing legal guidance, and so on and so forth. In practice, the judiciary is not as independent as it should be. And I say this for the following reasons. My lady has touched on some of it, or maybe most of it. One of the reasons that I identified, or obviously that speaks more to me, is the appointment of judges. The office of a judge is one that requires utmost integrity and honesty above anyone in society. And as such, the process of appointing of judges ought to be very thorough, transparent, and corrupt-free. In the Gambia, as with other jurisdictions, I believe Nigeria and Ghana has also mentioned it, the president, on the recommendation of the Judicial Service Commission, appoints judges, except the Chief Justice. Appoints the judges after consultation with the JSC. That is section 138. In the JSC, the president nominates someone to sit as a member. Now, in some countries like Ghana, we've heard Nigeria, there's confirmation process by parliament. And I think the earlier speaker, the first speaker as well, mentioned what happens in the US. For us, I feel that we haven't gotten it right. We still have charged the politicians to appoint judges. We also have charged the politicians when it comes to removal of the judges. Now, the implication of that is not far-fetched. Can the judiciary be said to be truly important when the judges are appointed by the politicians in power. Would the judges dispense fair and just judgment, especially when it concerns the actions of a government that appointed them? We have an extremely vulnerable system of appointing judges, and our history has seen the consequences of such a system. We have given the power to the president, which is common knowledge that appointments by the president are based purely on political needs. If a person is well known to be a member of an opposition, would such a person be appointed as a judge? The same questions arise with the removal of judges. The Constitution provides similar provisions for the removal of judges, and my lady mentioned Section 141 onwards. And the power to remove judges as well is given to the president. Though our Constitution provides for a further step, which guards the security of tenure of the Chief Justice, the Justices of the Supreme Court, and the Court of Appeal and the High Court, where they may only be removed from office for inability to perform functions of his or her judicial office, whether arising from infirmity of body or mind or for misconduct. And there's a process, a constitutional process that has to go. A notice has to be given to the Speaker, signed by no less than half of all the voting members. And then an independent tribunal is set up, made up of 3 persons, only one of whom has previously held judicial office. In all my years, I have never seen this happen in the Gambia. So we have it on paper, but it's not practiced. Another point we have that weakens our judiciary is the remuneration of judges. Of course, over the years, we have seen great improvement from when I first started. And judges are also entitled to receive allowances and other benefits from the government. Recently, there was a bill, Judicial Officers' Remuneration and Other Entitlement Bills, which regrettably fell through Parliament. Even though this bill is provided for in Section 142 of our Constitution, that such a law should exist. Judiciary's budget, as allocated currently by the state. My lady touched on that when she said that despite what is said in the Constitution, it is not really what happens in practice. Again, we have what the Constitution has provided for us to do, but we don't really practice it. So the budget of the judiciary is still determined by the executive, the ministers, etc. Now, I know we have little time left, so I've skipped a few things and I haven't gone into much detail, so forgive me for that. But these sections have been touched upon by my lady. Now, in conclusion, Section 17 of our Constitution provides that the fundamental human rights and freedoms enshrined in the Constitution shall be respected and upheld by all organs of the executive and its agencies, the legislature, and where applicable to them by all natural and legal persons in the Gambia. And most importantly, shall be enforceable by our courts in accordance with the Constitution. That means everyone, each and every citizen, person, wherever they may be in the Gambia, the executive, its agencies, everyone should rely on the enforceability and the independence of the courts. It's a huge responsibility that members of the judiciary take. Judicial independence is therefore so essential in the dispensation of justice that every legal thing possible should be done to preserve and uphold it. Security of tenure must be upheld, such that once appointed, a judge is entitled to serve on the bench until the age of retirement, unless where an independent tribunal established for that purpose has ordered that a judge be removed from office upon proof of the allegations of misconduct against him. Having said that security of tenure is important, it is equally or even more important that we have to look at the appointment of judges. In order for there to be a lifetime appointment or appointment up till retirement, then the quality and the caliber of those persons must be highly, highly vetted. That is my observation. So my recommendations are as follows. The appointment and removal of judges should be removed from the executive completely, and it should be retained within the confines of the Judicial Service Commission. And there should be a mode of confirmation or approval by the National Assembly. The tenure of judges, as provided by the Constitution, should run until life, run for life or retirement, and a removal only as provided following the investigations of an independent tribunal. It shouldn't be at the whim of any political person in government. Having security of tenure truly brings about a sense of wholesome independence, as the judges will know that their tenure will outlive the current executive, and as such will most likely exercise their powers truly and faithfully without any fear or prejudice. The judiciary should be financially autonomous. We should be able to, the judiciary should be able to receive their budget allocation directly, perhaps, if the role of the central bank, I think in Nigeria, the central bank does it, completely autonomous from the executive. They cannot be determined by the executive of how much or to reduce even what their budgetary allowances should be. On the criteria of judicial appointments, this should be reviewed. And currently we only look at, the Constitution only speaks of qualifications and terms of being qualified as a lawyer. However, I think that should not stand alone. For our society, we have to have an additional criteria, and which is to look at the men and women of integrity. We need to look at their financial backgrounds. We need to scrutinize their finances, just as we do before electing a president into office. We need to know who these persons are that will be sitting on the bench determining the lives and faiths of the society as a whole, whether they be at risk to corruption or bribery, etc. I think ethically, the judges before, a judge from Nigeria mentioned that there was a time when judges used to sit exams, or that there was an examination process before appointing a judge, and I think it hasn't happened again. But I think in Gambia, it would be worthwhile to have an examination process to test the candidates that will be judges. I think that the office of the Minister of Justice and Attorney General should be separated so that the Attorney General, who is the head of the legal system, is not a political appointee. I think judges need courage and they need to fiercely guard against threats of judicial independence. We know that in reality, judges are constrained to maintain judicial independence by law, by their legal training, their expectations, and the judicial culture and society in general. However, those lacking courage should never consider to apply to be a judge. We must, as a society, be honest about persons that apply who are not fit for office due to integrity issues, and overlook in those instances their qualifications. Even if they have the highest qualifications, is there anything that makes there a shortfall in their integrity? And for those that are in office and are of fine standards, who rise above political movements, who conform to the highest standards of integrity, who disqualify themselves from cases they believe they cannot act impartially, who report colleagues of unscrupulous persons, or who have been approached by the public, etc. I think we should foster a culture that supports and rewards those courageous judges. Now, in closing, I want to ask questions that if we can discuss. Where have we in West Africa taken provisions that exist in our constitution that we are sharing by various drafters? Which jurisdiction started this to say that politicians should be involved in the appointment and removal of judges? And what was the rationale or reasoning behind this, especially in Africa, where presidents never seem to leave their seats. Why have we permitted this to go on as long as it has? I thank you all, and I wish you a pleasant day. Thank you.
Thank you very much, Mr. Raj. You dealt seriously with the issues that bedeviling the judiciary in West Africa. We thank you very much for identifying that the problem we're having ranges from financing, separation of power, mode of appointment of judicial officers, and recommending that there is need for security of tenure, quality of the judges that are appointed, and financial autonomy and all. Thank you very much. We have learned so much this afternoon from you. Thank you. At this point, we are going back to Elizabeth to further direct the webinar. Hello, Elizabeth, are you there?
I think we're going to do the plenary section now, the question and answer session.
Yes. Okay. All right. I see that we've had questions that on the chat box, and all the questions have been directed to what have been discussed. So I'll take the first one here, which I think all the panelists may want to give an answer or two. It's from AKCC. It says, given the similarity of challenges faced by the judiciary in West Africa, insofar as independence is concerned, what will be the single most important recommendation of the panelists in this circumstance? Okay, I think we will start with our last speaker, Ms. Farage, because I think you made some recommendations. Perhaps you may want to just quickly draw our attention to it again. Ms. Farage, please.
Are we responding? Sorry, because my internet went off slightly. Are we referring to the last comment?
No, the question is given to the similarity of challenges.
Sorry.
Faced by the, yes.
My recommendation. My recommendation that also Justice Alami touched is about the quality. I think if we have the quality of judges reviewed, I think the judiciary will then be able to educate the executive by way of either dialogue or the Minister of Justice or the Attorney General to show that the courts are really independent of the executive. But if the judges themselves do not believe that they are independent, then how can they teach the counterpart to respect that position? So I believe that the quality in terms of their appointment it should come first at the quality of people that assume these positions. And once we overcome that, I believe everything else will take time, but I believe that it will stem from that.
Wow. Thank you very much. Thank you very much. There's a question here, and I think Honorable Justice Jawara Alami may be in the best position to do justice to it because it's coming from your presentation, my Lord, sir. It says, it is clear from the submission, the question is from Sana Baji. It is clear from the submission of Honorable Justice Jawara Alami and the recent pushbacks between the Parliament and judicial of the Gambia relating to the accounts of the judiciary, which shows the lack of financial and administrative autonomy of the Gambia judiciary, contrary to the constitution. Couldn't this be resolved through a judicial review for greater judicial independence? How do we resolve this impediment moving forward? And I think that the thing we may want to understand here is, having these issues, what particular review, Honorable Justice, do you think will be in the best interest of the judiciary, not just in Gambia this time around, but in West Africa? Honorable Justice, sir.
Thank you very much, and thank you, Council Baji, for that question. Well, it has been in the papers in the past week about the back and forth the judiciary has had with the Financial Oversight Committee of the National Assembly. And again, even though the judiciary may have been at fault somehow, because nobody knows the real story of what happened. But I believe it impacts on the independence of the judiciary. And for us to be able to really say that we're independent, we need to be financially autonomous. The section in the Constitution 144 that gives us the financial autonomy, the self-accounting, should become a reality. The judiciary should not have to be subjected to answering questions before the National Assembly. The way the Constitution is couched anyway, the budget of the judiciary goes to the President only for comments, no amendments, and then it goes to the National Assembly. So if that power is given to the judiciary to ensure that there's independence, then how does a committee with financial oversight have the right to question the judiciary and go back and forth with the judiciary? Again, dialogue is important. I think the National Assembly needs to be made aware of what the Constitution says. There has to be some form of or other mechanisms put in place where oversight, of course, you can't have any institution without oversight. You must have oversight somewhere. But is it the financial, the committee at the National Assembly level? I suppose it's a constitutional requirement. But the problem is the judiciary is seen as the Ministry of Justice in the Gambia. It is not seen as a separate arm of the government. And I think that's where the issue lies. I think I'll stop here for now in case anybody else wants to comment.
Thank you very much. Thank you very much. Okay, we have two questions that are similar. And Professor Gabriel, if you see here, I think you may be in a better position to give us a view on these two questions. Number one, as a young lawyer with aspiration to be a judge, which area of law would you advise me to master in further studies to be a good and resourceful judge for my country and Africa as a whole, taking into consideration the advancement of technology in the world now? The second question, which is similar, is what role can lawyers play to minimize or, if possible, eradicate judicial corruption and bribery among some judges in West Africa? Prof, yes.
Can I go on, Chidi?
Yes, please, sir.
Okay, yeah.
Sorry, Prof. Sorry, Prof. Can you just make that in 2 minutes, because time is running out on us.
Okay, maybe I'll just listen. I'll go to the first one. For an aspiring lawyer who wants to become a judge, yes, you should know the constitution of your country, study constitutional law, particularly constitutional analysis. It's very important. You must understand the rules of interpretation of statutes. And if your country belongs to the Commonwealth tradition where judicial precedent is very important, you must know how to analyze cases, and respect judicial precedents so that you are not accused of judicial rascality by your seniors. That's very important. And then you should know all aspects of the law. As many laws as you know, there are emerging areas. I know some judiciaries, like it happens in my country, may have divisions. You may have the criminal division so that judges who are into criminal law may handle cases that border on crime. You may have the probate division. Then you have judges that have commercial cases assigned to them. But basically, you must understand judicial statutory interpretation, very important, and know the ethics of the profession. And then what role should lawyers play to stop judicial corruption? The first one, lawyers should refuse to be conduit pipes for corruption. Most times, politicians use lawyers. And number two, lawyers must keep to the ethics of the profession. You find lawyers telling clients to cook up facts. Do this. That is how we can win this case. Lie. Come up with lies. That is wrong. So lawyers must uphold standard. Lawyers must refuse to do the wrong things. Lawyers should not mislead the courts. Thank you so much.
Thank you very much, Prof. We are very grateful. We are running out of time, seriously. But Honorable Justice Joe Archer, if you could help us with a view on the question asked by Tuko Mburu. It says, how do West African judiciaries receive funding and what is the process of managing these funds? For example, in Kenya, judiciary submits its annual budget to the Treasury. After approval by Parliament, the Chief Registrar, who oversees the administrative functions of the judiciary, is responsible for administering the accounting for these funds. I think the issue here is, how do we come out of this financial independence, of financial dependency of the judiciary on the executive? Honorable Justice.
Chidi, can you hear me?
Yes, I can.
I think basically that is all we have been talking about.
Yeah.
Money due to the judiciary should be given to the judiciary en bloc. And there cannot be any system without checks and balances.
Yeah.
The auditor, you could have the office of the Auditor General residing with the executive. At the end of the year, you audit the expenditure of the judiciary. For such money to be released to the judiciary that runs its accounts, which should be audited at the end of the year. But what is happening now, particularly in most states in Nigeria, is that the head of court goes to the head of the executive, that is the governor, to ask for specific releases, for specific items, specific projects, which should not be. Usually, monies are budgeted at the beginning of the budgetary season. And as has been said, you find that it's the governor that presents even the budget of the judiciary before the assembly, the State House of Assembly. So you have this envelope system where the governor gives the judiciary what he thinks the judiciary should have. So there should be a mechanism for the monies due to the judiciary to be released periodically, if not once a year, probably quarterly. But such monies should be audited, such expenditure should be audited at the end of every year to ensure proper accountability. Thank you.
Thank you very much, Honorable Justice Archer. We truly appreciate your time. I'm sorry, so much far beyond time. I think this is where we draw the curtain with respect to question and answer. Elizabeth, back to you.
Yeah, thank you very much, Chidi. It has been a wonderful and insightful discussion. The following were identified as threats and challenges to judicial independence in West Africa. We talked about political interference by the executive, lack of financial autonomy / withholding of funds by the executive, corruption that leads to the integrity of judicial officer, intimidation of judicial officers and their families, lack of transparency in the electoral process, lack of transparency in appointment and removal of judges. And the following were also stated as the mitigation strategies: exploitation of exploiting the e-justice system to the allocation of cases, providing adequate security measures for judges and lawyers in sensitive cases, security of tenure of judges, appointments and removal of judges should be removed from the ambit of the executive. Then there should be financial autonomy. Then the Gambian speakers said that they should the Attorney General's position should not be a political appointment. Then lastly, those appointed as judges and those appointed as judges should be people of integrity. Thank you very much. Then the way forward. The way forward will be moving to the Francophone African countries to ascertain the emerging threats to judicial independence in those countries. The webinar is being recorded and will be released, and the webinar has been recorded, and the reports and the recordings will be released, which outlines the issues that have been raised with the commitment from the Ghana Bar Association, Gambian Bar Association, West African Bar Association, and West African Law Students Association to continue to work together to address the issues that have been raised. I thank everyone for making our time to attend this webinar. I especially thank the distinguished panelists for making our time to lead these discussions. We've learned a lot from your insightful discussion. I also thank the organization that partnered with us, and I thank